This is exactly why courts take bail violations so seriously. The judge's tone right out the gate. Cold, controlled, but you can already feel it. He's setting the tone for zero tolerance. Notice how he confirms everything on the record. Slow and deliberate. That's not just formality, it's to make sure there are no excuses later.
Just 3 days after being handed probation, this man was back committing crimes. You have to wonder, was probation ever a real opportunity for him, or just a brief pause between poor decisions? And for the judge, this isn't just a timeline, it's a statement about risk to the community, one that says leniency might not be working.
And 3 days, within 3 days, you committed these crimes. I'm only calling the misdemeanor case at this time. We will go on the record in the matter 23 CF 214, State of Wisconsin versus Bradley Scheuer. Oh, sorry, that's the 20. I'm not calling the new case.
Oh, you're not calling.
No, I'm only calling the, wait, you're right, the new case.
Do you want me to sit back in the?
Actually, no, you're right. I am only going to call the new case. And then I will call the old case after Mr. Davis excuses himself. So start anew. We will start afresh. We will go on the record in the matter 24 CF 202, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Scheuer in person in custody with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing.
Now we're entering the delicate world of plea negotiations, a legal chess match behind closed doors. Both parties have reached an agreement, but don't let that fool you. These deals often walk a tightrope between what's provable and what's politically acceptable in court. But will the defendant stick to his end of the deal when the judge starts digging deeper? That's the real test, Persion.
The parties have reached an agreement. Mr. Scheuer is currently in custody facing revocation on another matter. Mr. Davis, what is the agreement that's been reached?
Look at that. The defendant isn't just nodding, she's shrinking. When a judge starts listing the number of previous failures to appear, you know this isn't a what-time mistake. Judges remember patterns, and patterns of irresponsibility. They rarely end well.
Battery, and it was just for both sides free to argue on this case.
All righty. So both sides free to argue in 24 CF 202.
And I should say at that time, District Attorney Renicky, I know that he always would include dismiss and read in. So those other two are not dismissed outright, they're dismissed and read in.
That is correct. All right. So Mr. Schmidt, what is the basis for the public interest in reaching this agreement?
I think being free to argue on that misdemeanor is fair. I think the way
Listen carefully here. The prosecutor begins softening the charges, calling one account a little iffy. That's legal speak, for we might lose that one. This is where courtroom reality hits. Not every disturbing accusation can be proven. That's why they're anchoring the case to the misdemeanor battery, the one thing the state believes it can absolutely prove.
false imprisonment was described by the victim, it's a little iffy. The strangulations are always about the effect on the victim, so there's always come down to testimony. The battery is the thing that we can certainly do. So I think that doing that and arguing with the read-ins is appropriate. Thank you.
Victim's rights compliance. Victim wish to make a statement. No statements made. All right. So, Mr. Scheuer, I have in front of me a plea questionnaire waiver of rights.
Okay, here it comes, the moment of reckoning. The prosecutor lays it all out, and it's bad. To miss court dates, meth charges, and a complete disregard for supervision rules. This isn't about being unlucky. It's about being reckless in the eyes of the court.
Word for word.
Yes.
And do you understand everything on this document?
Yeah.
And if you didn't understand something, did you have him explain it to you?
Yes.
And he did so.
Yes.
Now comes the ritual, the plea colloquy. It's like a legal lockbox. The judge must confirm that every constitutional right is being surrendered knowingly, willingly, and intelligently. This isn't just formality, it protects the system from appeals and ensures no one walks out later saying, "I didn't understand." It's also a moment where the courtroom gets quiet, because once the rights are waived, there's no going back.
And is that your signature on the second page?
Yes.
So you were pleading guilty to one count of misdemeanor battery, is that correct?
Correct.
You are 66 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Correct.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
Well, I'm on heart meds, but
That's
no.
all.
Yes.
No medications that interfere with your ability to comprehend or understand?
No, I've been incarcerated for 6 months.
All right. And so,
Watch how the judge pauses right here. That's silence. That's power. It signals gravity. And when he finally speaks, it's not just disappointment, it's control. Every word is measured. He's not yelling. He doesn't need to.
that you'll no longer have a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand the rights that you're giving up here today?
Yes.
Now, do you also understand that if you're not a citizen of the United States, your plea could result in your deportation? If you're not.
Yeah, I'm a citizen.
I know, I have to ask that to everybody. Do you understand that the state would have to prove on or around September 6, 2024 in Burnett County, Wisconsin, you caused bodily harm to JEC by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Now the defendant tries to speak finally, but it's too late to rewrite the story. Her explanation might sound emotional, even desperate, but to a judge who's seen hundreds of these cases, it's just more noise over a broken record.
Free to argue here. And that means that the state is free to argue for any sentence it feels is appropriate based upon the facts. Your attorney is free to argue any sentence that he and you feel is appropriate based upon the facts. But I'm not bound to follow either of those arguments or recommendations. Do you understand that?
Yes.
That I am free in my own discretion based upon the facts of the case, as well as the totality of the circumstances, your history, rehabilitative needs, etc., the community, to sentence you to what I believe would be an appropriate sentence. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, did you go over that probable cause section that basically says what happened and why you were charged with the crimes?
Yes, I read it, but I don't agree with
And
it.
here's the line that seals it. You've had chances. That phrase is courtroom death. Judges don't want to babysit adults. Once the court believes you've wasted their time and the system's grace, mercy takes a backseat.
Those facts.
And just like that, everything stalls. He says, "No, not accurate. That's a bombshell." The moment a defendant refuses to acknowledge the basic facts of the charge, even under a plea deal, the judge is legally bound to reject it. And the tension, you could cut it with a knife. Because this plea bargain, it's suddenly on life support.
Are they essentially accurate?
No.
Well, I'm not taking his plea. We're going to go to trial because he's contesting it. He doesn't believe he did anything. We're going to trial. Okay, Mr. Davis, let's set the matter for trial. Then I'll move ahead and I'll sentence
I
him on
agree.
the other
I
matter.
understand what you're
No,
saying, but I do.
Nope, because you're not admitting to what you did.
Fine, I admit to it then.
Mr. Scheuer, I am not accepting a plea of an individual who is not going to be accountable and responsible for their actions, especially when it involves a battery to a person, a battery to a victim who did not deserve to have you put your hands upon them. Do you understand that?
Yes.
Now, if you're willing to accept that responsibility and admit to what you did, I will proceed and accept a plea. But if you are not, then we will go to trial.
The judge isn't holding back now. She draws a clear, sharp line in the sand. Admit to what you did or prepare for trial. There's no middle ground. This isn't about technicalities, it's about accountability. And right now, the courtroom is shifting into high drama as the judge demands honesty, transparency, and full ownership of what happened that day.
And I want you to tell the truth and be honest with what you did and your actions that day, or we will go to trial. I do not have any preference one way or another. I will not.
Boom. Bail revoked. This is the tipping point. Notice the quick delivery, no drama, no build up. Just finality, and that's intentional. Judges use flat, emotionless tones when they want the weight of a decision to speak louder than their words.
That is the justice system. So, Mr. Scheuer, I will again ask you, what did you do that day?
I put my hands on her.
You did. Did you? You put your hands on her.
That's what I'm charged with.
Yes.
Yes,
Did you put your hands
Yes.
on her? Did you have a right to put your hands on her?
yes,
You had a right to? The law says you can put your rights upon a person?
no,
Did you have a right to put
No.
your hands on her? Now, Mr. Scheuer, so you put your hands upon JEC, is that correct?
yes,
Did she give you consent to do so?
no,
Did you have a right to do so?
no,
Did you cause her harm?
yeah,
What?
yes, I said.
Yes, you caused her harm. Therefore,
There it is, a direct admission of harm. Simple words, yes, I caused her harm, but they land like a gavel drop. That one sentence carries the entire weight of guilt. It changes everything. Now the plea has a pulse again. But it also raises a deeper question. Why did it take so much pressure for him to speak this?
Mr. Scheuer, are you guilty of battery?
Yes,
Now, with regards to the facts of the case as it relates to battery, did you review that with your attorney?
yes,
Now, Mr. Scheuer, tell me right now, those facts as it relates to a misdemeanor battery, are they not 100% accurate, but are they for the most part as it relates to battery accurate?
yes,
Are you telling the truth?
yes,
Raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Scheuer, are you telling the truth here today that the facts alleged in the criminal complaint as it relates to the misdemeanor battery are for the most part accurate?
Yes,
Are you stating here today that you in fact
Now look at her face, that moment of realization when consequences become real. This is when defendants stop thinking like manipulators and start thinking like people, but often, it's already too late. Here's the irony. The defendant could have walked free months ago if she had just followed basic instructions. No need to be perfect, just show up. Instead, she's learning the hard way that freedom doesn't wait for second chances. Last note before sentencing: this is where the judge almost always gives a final warning. A speech to remember, but in this case, he doesn't even bother. That silence says it all. She's not someone he thinks will listen, and that's chilling. This case is more than just another court hearing, it's a crash course in accountability. Tina Sally didn't just break the law, she broke the court's trust. And when trust dies in a courtroom, so does leniency. If you found this breakdown insightful, hit that like button, drop a comment below with your thoughts on the judge's handling, and subscribe for more courtroom drama decoded with real legal insight. See you in the next case.